Hello, Mr. Joseph.
Hey, good morning, everybody. We're waiting for a few folks to trickle in. I wasn't 100% certain we'd have much of a showing today. I set this thing up for automatic on Zoom, and then I sent out a reminder email on Friday. So this was a little bit of an experiment to see how that apparatus might work. I'm going to start more of an aggressive online campaign with Meta and LinkedIn to try to get the word out to more people. I'm going to be spending a little money on that front. So you're still, we're still going to have these bi-weekly meetings. I'm not going to be able to be on the 5th of October because I'll be flying back from an out of country meeting on that day, but I'll try to schedule it, and I'll be gone like the 30th through the 5th. So I will try to schedule something the very next week, the week of the 12th, to get us back on schedule. But I'm also going to start holding more like Q&A type sessions with as many people as we can try to match up with on Facebook and LinkedIn that may be similarly situated.
Yeah, good morning, Joe. How you doing, man? This is Daryl.
Good morning, Daryl. How are you?
All right, I'm good, man. Thank you for doing this, man. I've missed a few of these. I've been out of.
Hey, that's a good point. I'm glad you guys are bringing that up. I'm going to drop this. This is another project I'm working on. I have this separate website that is that you guys can share with your friends and family. I'm going to put this in the chat in a second. As soon as I figure out how to expand my screen. This for everyone. I'm going to put this in the chat for everybody to link to. This is our ongoing government website. Our government, it's U.S. government OT rights is what we just picked. It doesn't mean a lot, but what I want you to do is go to there's a link in there for the information sessions, and I'm going to build on this. This is like our last two webinars. And I'll do a share screen so you guys can see what I'm talking about. But this is what that should look like. If you guys, let me know if you guys are looking at my U.S. Gov Rights screen.
I got it.
Yeah, down here at the bottom, I'm going to just start stacking these webinars down there. And so every one of these is recorded. I went through and edited. I'm going to do some video editing right now because some of you may or may not like, hey, I don't want my questions put on there. So I've been trying to go through and edit out some of the stuff where you guys are necessarily on the screen. But the idea, I mean, it's pretty much a closed system. This is the only folks who are seeing this is generally folks that are part of this case or want to be a part of this case. So, and I also, as you guys know, I send out an email after sometime today, early tomorrow, I'll send out an email to all 250 or registrants that are somehow one degree of separation from this case, so that you have a link to the video and you can see them. But we're building a library of them. The idea is that each time we get on this thing, you guys ask great questions. Somebody comes up with a question I haven't heard before, which is fantastic. And that'll give other people who aren't able to join an opportunity to learn from our discussions. Does that make sense? And so today, I mean, we've got the normal, like a lot of the normal folks that have been on here before. What we're gonna use these Q&As for is if you don't have a portal open up, this is a great time to let me know, because I can literally go on and fix this right now. If you haven't joined the case, I'm going to drop another link in to the chat, which will allow you to join. It's just a form that you fill it out and you'll end up in our pipeline, and we'll have you in the case within the next few days. It gathers a little bit of just perfunctory information to make sure that you guys, to make sure that people who are signing up fit in the case. We're basically charged as gatekeepers. Like a lot of folk, the government won't get around to contesting whether or not somebody belongs in this case until way down the road. So I'm serving as gatekeeper now my team and I are working as gatekeeper to make sure you fit within the four corners of the case, which is again just basically anybody who worked for the government and either in most cases they were either misclassified as independent contractors, they could have been classified as PSCs but were denied overtime rights, minimum wage rights, or were somehow treated differently, meaningfully differently from their W-2 GS counterparts. If that makes sense. So those are and now we have this additional wrinkle. I call it a wrinkle. It's actually kind of an additional mechanism for getting you into the case, which is those who were illegally fired. I'm going to drop this form link in here now into the chat. And this is a way that if you think you belong in the case, but you're not 100% sure, fill this form out. Again, you'll end up in my pipeline. It'll normally be, I'm the one who's doing most of the direct one-on-one contact. I think I shared with you guys the last time. I've actually enlisted, I've got 35 people that work in my firm, but I've enlisted my wife, who hears me talk about this case every day. She's working at home on this too, making sure that we don't accidentally miss anybody. So anybody that submits a form, we're having like 2 or 3 sets of eyes go over it, make sure that we get everybody in this thing that should be in this thing. So if you hear from another Whitcomb, it could be a Carolee Whitcomb. That's my wife. She's here. She's on my payroll. She's doing, it's all legitimate. She's part of the firm. She owes you the same confidences that I owe you, but she's just making sure that folks get, that no one gets missed, because I'm doing the informational side of this thing, making sure everybody knows what's going on with the case, make sure that I'm fighting with the court. That's kind of my primary job, is to armor up, go and do battle with the court and the Department of Justice. The rest of my team is making sure that everyone who ought to be in this case is. And then we're gathering the other part that most of you have heard me talk about, is we're also gathering your stories, turning those stories into affidavits, getting your signature together so that when we go to certify this quote unquote, we call it a class, it's really a collective action. But when we go to certify the collective action, then we are able to do that. Now, Jason just dropped something in here, go to the DOJ. We're going after several agencies, Department of Justice being one of them, but primarily the VOA, for retaliation because of these giant layoffs that between the government and Doge, all these layoffs. The ones that were connected to the VOA, they happen on the heels of this case, so we're arguing retaliation. And that may look like, for those of you who aren't in the case, that may look like a trip up to the Court of Appeals. Well, that almost will certainly look like a trip up to the Court of Appeals as it relates to the retaliation claim. But if we win that fight, and I strongly feel that we will, that opens up the damages model for not just looking backwards at back pay, but looking forward at forward pay. That opens up the universe of damages significantly. I'm gonna be quiet now. I'm gonna open up the floor. We're gonna do what we've done before. If you guys look at your screens, there's 20 of us on this call now, so I want to make sure that everybody gets a chance to ask a question, that nobody talks over everybody. So if you look at the bottom of your screen, along the bottom there's participants chat and then raise hand. If you just click that button to raise your hand, thank you. I'm gonna do a terrible job with the name. Bakhtiar. Guys, I'm gonna just raise their hand. If you want to ask me a question, we'll go ahead and I'll just answer the question that you're asked. First, help me do a better job pronouncing your name.
Yeah, my name is Bakhtiar. So why I'm saying, one of our coworkers, she signed contract with you, but she's not receiving any emails from you in regards to this conference call, like meetings and stuff. So she's worried that maybe you didn't get the contract or something is missing in between, like, in the
No, it's probably not that. What a few folks have done is, whether they meant to or they didn't, they checked a box, an opt-out box, which is what blocks us from being able to send out email. We have to be very conscientious about the Canned Spam Act. It's a terrible name for a law, but it's.
She just wants to know what she has to do in order to get back online.
Let me get, since she's talking through you, by the way, you guys, when you guys get these links, you can forward them to whomever you think would benefit from them. Let me look and get her name and see if she's. No, it's not clear.
Cool.
Accidentally tried loading to the wrong software. All right, what is your friend's last name?
So her name Anna, ANNA,
Yep.
and
Is
last name
also?
last name is Zamanov. Z as in zebra.
Same as yours, right?
Right.
I'm looking at it. I'm looking at her documents. She has a signed engagement letter. She's in the case. We got a signed engagement letter from her in July. So I'm guessing I've already submitted her form to the court, because I was at the time back then I was submitting forms. Forms have sort of slowed down. That's why I want to re-engage folks in campaign. Let me see if I've got her client portal open. I've got a client portal open to her. She sent me a thank you. And then the last thing, I'll look to see if she's in she may be, like I said, some people accidentally opted out of communications. It's kind of a natural reaction for a lot of people. They just,
Is it possible you'll resend it so she'll get it?
Sure, 100%. I'll do it right now. My software gives me fits sometimes with, and the other thing she wants to do is, I'm going to create an email for her right now. To opt-in communications. All right. In the case. To be updated. Also, have her check her spam. A lot of folks have alerted me to the fact that they were not, that when I pointed them to their spam, they were able to find it. I'm also engaging my tech person to make sure she gets on the notes.
No spam. She doesn't have it in spam.
Okay. I just sent her an email. She should get something from me now. She's definitely signed up. I'm going to send her something through the client portal again. But I'll make sure that she's on. I've got a comprehensive email list of about 380 folks. And the one thing we want to make sure when I talk to her, I just sent her an email. So if she replies back, I'll know I've got a good email for her. That could be the only other hole, is that sometimes people inadvertently
Hi, I got it.
misenter their email. All right. But
All
I'll just
thank you.
her thing. I'll shoot her a text too. That's a good fail safe. And then say, hey, just double check your email. This is what I've got. Make sure I've got the right email, because I use a lot of text messages for this purpose.
All right. Yeah. Thank you, sir. I appreciate it.
All right. Who else have I got? All right. Jason's got his hand up. Go ahead, Jason.
Hey, so I'm actually hearing a lot from some FTEs too, who have a lot of questions, and I'm kind of forwarding them your way just to clear the air with some things. I wanted to see if you had gotten any FTEs asking certain questions about what's going on right now.
Well, we haven't been getting a lot of calls to the switchboard on that front. What I'm going to try to do, Jason, I gave birth to this idea literally this morning. I'm just going to, I've been doing these presentations for over a year, been doing them every other week. I usually come in with a little bit of an agenda. What I thought would be a good idea is maybe just doing shorter, maybe 30-minute, more frequent, like just straight Q&A sessions.
Right.
having them calendared, doing like a, maybe not doing them on the weekend, but maybe because I'm Denver time. So if I did something 4:30 Mountain Time on a Friday, I'd probably catch most of the folks that are on the East Coast at home, and then some of the West Coast folks might be better to do it earlier in the day. But the point is, I could just do like a 30-minute Q&A session just to give folks an opportunity to come in and say, hey, what, like, because right now, like for everybody who's on this call, where we are posturally right now is I'm putting together this, what I call it an omnibus retaliation claim. That's going to be by itself. It's going to be the only issue in the fight, because what we expect is going to happen, what the court has signaled it's going to do, is dismiss it on jurisdictional grounds. Okay, guys, I don't want to turn this into a law school 301 class, but right now there's a lot of legal, almost academic level debate going on right now that we've accidentally unearthed about which court is the right court to handle these retaliation claims.
Was that taken care of in the very beginning, though? It would have had to have been.
What's that again?
It would have had to have been taken care of in the very beginning, which court we're supposed to be doing this in would have been in the first court case, I thought.
So we did that part. So not the whole case. So when Jason, you're obviously you're the first name plaintiff, right? So when we brought your case to the trial court, the first thing, as you remember, the first thing they objected to is, hey, FLSA claims against independent contractors can't be brought here, because remember their argument was under Title V to be an employee of the federal government required appointment. That was their first argument, right?
Right.
And then when we won that fight at the Court of Appeals, we brought it back and we added the retaliation claim, because literally, this is all backstory for you. I think you and Daryl know this. Many of you, some others might know this, but the literal day that this went back to the trial court in, like, call it June 13th or 14th of 2024, thereabouts, the VOA fired like 50 contractors on the same day. And then again, and I think you'll excuse me for sharing a little bit of your personal story. Even before that, back in February, because the case went, the Court of Appeals remanded our Jason Lambro case, which Jason was like the sole litigant in that case, remanded that case in January of 2024. Almost immediately, the State Department, which is the agency that Jason was working for, and I don't feel like I'm giving away state secrets because all of this was incorporated in our new complaint. Okay. The agency that Jason went to work for immediately started giving him grief, started complaining about his work. I mean, literally on the heels of it, right? And started complaining about his work, and then just fabricated a reason to fire him. And then he moved over to the DOJ from there. Now, based on that, we started formulating a retaliation claim. And then fast forward to June of 2024, when the case finally made its way back from the Court of Appeals after some really ridiculous delay tactics on the part of the government, made its way back to the court, made its way back to the trial court, literally on or near that day, within I'm talking 24 or 48 hours of that, based on what I remember reading. And I think Daryl was a part of this. I know that I know there were some others. I know.
Oh yeah. I definitely was a part of it. I remember.
Yep, that were just summarily fired. So 50 folks were just summarily fired without notice and without really any intelligent reasoning other than we don't need you anymore. So we filed our retaliation claim. And Jason, this goes to your point. We filed this retaliation claim as part of an amended complaint in July of 2024, July or August of 2024. The Department of Justice immediately turned around and filed another motion to dismiss, arguing that the retaliation claim didn't belong in this court. They pointed to some 1990s case law that relied on some 1970s Supreme Court precedent, which for all of you legal geeks on the line, which is probably just me, all of that case law predated a change in the Fair Labor Standards Act, which added the retaliation element in 1977. So I tried to go up to the Court of Appeals and argue that the court's dismissal was illegal, the court said, well, because of the posture, because the judge didn't actually let us amend the complaint and then dismiss those counts, he just denied my request to amend the complaint, that it wasn't right for the Court of Appeals.
Need you to get the fuck up off my ass.
Hey, Cheryl, we can hear you. Your mic's open.
Sorry.
So I didn't know if that, I thought she was directing a question to me. Thanks, Jason.
I think she's in traffic.
Yeah, that makes sense. Yeah, it sounds like me in traffic. So, so the point is that we are now going to file a because of how weird this case is. And again, a lot of you might be new to this case and don't know, but so, and I'll say Jason and I, we've been kind of creating new law since we started this case. Before Jason's case in 2021 rather, January 2021, no one had ever tried to sue the government for misclassifying its employees. We didn't know that when we filed the case. We just thought this looked like a garden variety FedEx case that had gone through the courts many, many times. But apparently the wrinkle with the federal government was this Title V thing. We've won that fight. Now we're going up on retaliation. They're raising a similar jurisdictional issue, which is this Court of Federal Claims is supposed to be the only court in the country where you can bring a claim against the government other than Title VII or FTCA claims that are above the $10,000 threshold. My argument is no, the Fair Labor Standards Act is its own statute. It has its own cause of action. It has a separate carve out that says if you fire somebody in retaliation for bringing a Fair Labor Standards Act claim, then you get all this suite of damages. So that's the fight we're fighting now. What I want you guys to all know is it's all preserved. We haven't, no one's lost anything because all of this is all brand new. I'm putting together this complaint. And to your point, Jason, as far as retaliation claim, we didn't really have a bona fide retaliation claim prior to the case going back because no one had been fired or disciplined because of the claim until 2024 when it started happening to you. And now we've got, I think, 1,500 VOA people that we can point to that says that this was retaliatory as relates to this case. So again, the benefit of that is that everything we've done thus far in this misclassification over time, all of these rights that you guys were all universally denied, it's all looking back in time, right? It all looks before it all. It's all looking at things that have already happened, and we're going to try to go. Our job is to go and get you paid and compensated for historical missteps, things that the government did wrong in the past. The retaliation claim is looking forward. So let's say, and I'm going to pick on Jason again. Let's say he's working for the DOJ and he's making, I'm just going to use round numbers, he's making $100 grand a year. And they retaliated against him because of his involvement in this case and being a named plaintiff in the case. We have lots of facts that support an argument for retaliation. And they fire him. And now the next job he goes and gets pays 80 grand a year or 90 grand a year. Then it's the government is on the hook in that scenario, looking back to the date of the firing for the difference between what he's made and looking back to the date of firing and what he lost so far. And looking forward to the difference between what he's making now and what he was making, but for the government's firing.
That includes like raises, cost of living, and everything else, right?
What? Yeah, like I said, if you make it's baked in 10 grand a year, right? Plus looks forward. And what you normally have to do in that case, for all of you who don't litigate for a living, what you have to do is you normally have to hire an economics expert to come in and say, well, based on this scenario, we think that his overall losses going forward equal fill in the blank. Could be, it could be 100,000, could be 1 million, whatever it is. It's our job to get an expert to say what we think it is, and then they'll have to go get an expert to say what they think it is. And of course, the numbers will be different. And then we just rely on the judge or, the judge in this case to say, I'm believing Joe's expert, or I'm believing the government's expert, or what they most typically do is, split the difference.
You want to tell them about your economics expert, the group that you hired earlier?
We hired an economics expert who's in the bullpen right now. We haven't sent them anything because we're still trying to get all of these narratives. It's a lot of work, guys. We're gonna hopefully by the time this thing is over, we're gonna have thousands of people in this case with 1,000 different stories. And the job of the folks that we've hired, it's called BDO. They're one of the 4 or 5 biggest accounting firms in the country. They're either number 4, number 5, but they have a forensic accounting firm, and their job is going to be taking your stories, creating a model, and from that model, be able to extrapolate what each of you were essentially do based on your narrative. Now, what the question I most frequently get in this meeting is, well, hey, Joe, you know what, we didn't clock in and out. I don't know how I don't have a way of really proving the hours that I worked. The good news for you on this front, and any litigant that's in this misclassification and overtime theft and minimum wage theft scenario that you're in, is that the onus is on the employer to track hours. And if they fail to track hours, then what they're left with are the sworn statements of the litigants who are suing them, right? And they would have to affirmatively, if you say, well, I work 50 hours a week, and they don't have any proof to the contrary, that's a problem for them, right? That's a problem for the employer, whether it's the U.S. government or Domino's. And I've got a group of folks that are on this call that Sue Justice represents. We have a bunch of VOA folks. We have a bunch of folks that are in, let's call it the creative arts side, right? They're audio techs, editors, they're directors, or reporters, or journalists. They're whole. Everything you could think of that a news agency would do. VOA employs those folks, and USAGM employs those folks. Then we've got another crop that is folks from the U.S. Postal Service, and these are folks that I said Sue Justice, but that's actually the Social Security Administration. So let's use Sue's example. These folks are verbatim hearing reporters, and they go into the agency every single day, 5 days a week, sometimes 8, 9 hours a day, record hearings, and the purpose for which is to preserve the appellate rights of the individuals who are going in there and making claims against Social Security. For many, many years, those folks were on an individual contract with the federal government. They contracted on a per hearing basis. They kind of took the hearings they wanted to take and didn't take the ones they didn't want to take. And they got paid what I think most of them would have told you was a fair wage for doing that. Well, back in 2018, the government decided, oh, wait, we're paying too much for these services, and I think we can do a better job. We're going to put these out for bid. And they wrote 5 different contracts across 5 different contractors, and they put the onus on the contractor. So if Sue was working for one of these contractors, and there were a few, there were like 3 that I know of, and put her name on the list and showed up to a hearing, and that hearing got recorded, even though she may have driven across town, showed up 10 minutes early for the hearing, got all set up, and then for whatever reason the hearing was recorded. The contractor that she worked for got paid $5, and very often that was the amount of money that got passed through to the individual hearing reporter who was there. And that turned into a giant mess across hundreds of verbatim hearing recorders who got paid either below minimum wage for work that they were doing, or didn't get paid any overtime for the times that they were working. So I've talked to many folks who drove 100 miles to get to a hearing, didn't get paid for the drive, got paid $5 for the hearing that got recorded, and then had to drive all the way home. One lady related to me, she was there all day. She had 4 or 5 hearings that she was supposed to do, all of which got successful because it was a very remote area, which is not uncommon. All 4 or 5 of the hearings got canceled by the administrative law judge, or because the claimant didn't show up, and she got paid $20 for being there all day and drove all the way across the state to get there. So we've got a bunch of different facts. I've got a USPS client who's a named plaintiff on the case. She's delivering mail 12, 14 hours a day, and the net pay that she was grossing didn't even amount to the gross pay that the pay she was netting didn't amount to minimum wage. After she had to pay for her own car, had to drive all over, pay for all of her own gas, pay for her insurance, pay for all of these things. By the time she was done, she didn't make enough money to even amount to even federal minimum wage at $7.50 an hour. So there's a bunch of different stories and a bunch of different ways in which the government is taking advantage of folks that are like you. And I'm just going to keep doing these meetings, every other week, maybe more frequently if the demand is there, so that I can answer questions. And the only thing I really need I keep saying this every meeting, The only thing that I am looking for from you guys is your stories. Your stories are all I need to make this case. Because these stories will, to be fair, these stories will ultimately get reduced to sworn affidavits. And my job, my goal is to so overwhelm the government with this litany of sworn affidavits that they don't really have a choice but to come to the table with a checkbook. So, Jason, I'm going to ask you a question you already asked online, and maybe see if this is the one that you're talking about, which is, are we still looking at damages back to 28 or to the current date or earlier? The short answer is I'm trying to eliminate the statute of limitations altogether and go back as far as I can go back. Some of you as an example, Jason, we're working with the agency in 2002. The argument I'm raising now is it should go all the way back to when you started. And that's under the accrual suspension rule, which says that basically it's a Supreme Court precedent that says the statute of limitations does not begin to run until you knew or should have known of your rights. So at a minimum 2018, but I'm hoping it'll go back much further than that.
Is that coming up in the Court of Appeals, or is that the next one?
Well, we're waiting on Summers. That issue is in front of Summers now and has been since May.
He's not. He hasn't made a judgment yet. He's still just dragging his feet, huh?
Yeah, we're still waiting on him to issue a ruling. If he rules against us, what's going to happen is if he says, no, Joe's got it wrong, he's not as brilliant as he looks or seems, he'll rule against us and he'll dismiss certain claimants based on the statute of limitations. When he does that, that opens the door for me to take those claimants and that issue up to the Court of Appeals and get them to rule that we're right. So,
and that's where we do some of our best work. So let's face it.
Honestly, guys, I mean, it sounds like a vanity race. If you listen to me talk about this, it's like, oh, Joe just wants to go create a bunch of new law. I'm good at that work. I like doing it. That's how my brain operates. But if the government were to lay down and write you a check today, I'd throw you guys a party. I wouldn't like, oh, dang it, I don't get to make any new law. I'm happy for the government to capitulate and do what's right. But I'm also prepared for the eventuality that they don't do that. They keep doing what they have been doing, which is just drag this out for as long as possible. Just know that the more they drag this out, the more money ends up in your checking account. That's what you should know. We're doing everything. At least if I'm 10% as smart as I think I am, we're going to get these benefits. We're going to get these benefits going all the way back to the earliest possible date. And it's what they owe you times 2 for just the FLSA claim. And then the other piece, the other lane that we're operating in, guys, is the state-based claims. And that's going to vary claimant to claimant, state to state. So Jason in Maryland is going to have a different set of claims than Sue in Colorado is going to have, just based on their state-based claims. But each state that I'm aware of, and I've surveyed almost all 50 states, have some laws that says it's just flatly illegal to misclassify people. It's flatly illegal to classify people in a way that forecloses their ability to collectively bargain. It's illegal, and that's under an NRLA action, the National Labor Relations Act. It says you're not allowed to do anything that would prevent people from organizing in a union. And certainly the way they did it as a 1099 precludes it. I would suggest that even as PSCs, you were unable to really unionize the way you should have been able to. Jason, what's your next question?
Just talking about the sort of state going after them too. So we have another section in this group where we are going after the state for those people who lived in different states to help them out. But do we also have the state go after the Fed on a secondary level too for breaking these laws? So I work today for Techno Arts, and they, belong and work in Maryland. They broke lots of laws. I know we can go after them individually on a state level, but does that also break some federal laws since they're also a state-run or agency? Am I saying that right? I'm trying to.
Okay. Let me see if I can retool that a little bit for you. So you've got Techno Arts that's operating in Maryland. And they're serving a bunch of government contracts, right? They've got a bunch of government contracts, and they've got people like you that work for them. It's either W-2s or 1099. So I think on Techno Arts is a great example of, I think, that's broke, as you said, broke multiple laws, not the least of which is misclassifying its own people. Picking on you a little bit, like you and I have discussed this before. they've classified you as a 1099. Now, somebody will say, whoa, wait, Joe, I asked them to do that. And the answer to that, my response to that is nobody cares. Right? If one of my employees, if my receptionist comes to me tomorrow and says, hey, Joe, you know what? My life would be better if you made me an independent contractor. The only legal response I can give her is too bad. I can't make you an independent contractor because you want to be. The law says that if you're not, because very often in the case of, in Jason Lambro case or Anna's case is my receptionist, there's a million things that you're not armed to think about when you're applying for a job. Like, will I qualify for workers' compensation if I'm classified as an independent contractor? Will I qualify for unemployment insurance if I'm classified as an independent contractor? Will my employer pay my 7.65% of that one? Maybe people know about it. I'll have to pay my self-employment tax, but I'm not really worried about it because I'll get to deduct my car and my gas and the room in my house. But the other things, the workers' compensation, the unemployment insurance, these can be very valuable benefits that people unwittingly forfeit because they strike a deal that benefits their employer and them by going 1099. The difficulty is it's just the state's already seen this and they've already seen it in action. They're like, yeah, you can't do that. It's not legal. So the fact that you wanted to be an independent contractor, it doesn't matter. The fact that you signed a release that says, like almost everyone in VOA did, that says, I acknowledge that I'm an independent contractor and I won't dare tell anyone else anything other than I'm an independent contractor.
Right.
Actually serves more as evidence of the employer's attempt to cover it up than it does anything else. It's not evidence that you are actually an independent contractor. I
never understood how Technarts could be like, oh, do you want to be a W-2 or a 1099? Why would they even give you an option? It should be one or the other.
That's the whole point, Jason. They're not allowed.
Exactly. I'm throwing that out for everybody else out there too. And
they're not allowed to give you people. And the fact that you think it serve you, not relevant, right? Not relevant at all. What matters is if you walk, talk, and act like an employee, you are in fact an employee. That's a Joe Whitcomb paraphrase of the many, many different standards that apply to whether you're an independent contractor or a 1099. There are some exceptions that are usually related to your vocation, right? So as a lawyer, weirdly, I can go out and hire myself out. Now, I work for, honestly, I work for almost everybody on this call. I'm none of your employees. I've got contracts with almost every one of you that says I'm going to do work for you. And if I don't win, I'm going to be doing it for free. Right. Also, but I don't get to come back later and say, well, I was actually Russell's W-2 employee. Russell owes me minimum wage. I'm not allowed to do that because I actually work in a profession that has a baked in exception. Also, I don't check in any of the other boxes. I'm not exclusively Russell's attorney or Jason's attorney or Daryl's attorney or Cheryl's attorney. I'm just reading down my list of people on my screen, or John Mark's attorney. So there's no exclusivity. I'm using all my own equipment. I've got a 11,000 square foot space office that I operate in 3 offices across the country. So nobody, I can't point to anybody and say, well, you guys really violated the Fair Labor Standards Act. You guys work me like a slave. I work 80 hours a week and none of you pay me overtime. I don't get to do that, right? But in an instance where you're going to work for one employer every single day, using their equipment, going where they tell you to go, being there when they tell you to be there. And most of you, even if they don't have the employer will say, well, look, I didn't have a provision that said that Jason could only work for Techniarts. Sure. But you work Jason so many hours that if he was going to work for another person or another contractor, he would have to clone himself or engage in some sort of time-space continuum in order to be able to make it happen. So constructively, he's exclusive. He couldn't possibly work somewhere else. And the other thing is he checks the box that the lion's share of his money comes from one place. Maybe Jason has a paper route, makes a little extra money. Maybe he drives for Uber or DoorDash, but the lion's share of his money is coming from this one place. And that's the test. And I don't know if Jason does any of those things. If he did, I'd order DoorDash.
I'd pay just by charming good looks.
That's right. Russell Green's got his hand up. Tell me what's going on, buddy. Russell, you're muted if you don't know you are, bud.
Oh, yeah, sorry. So basically, I have a quick question. My question is, you mentioned in a previous call that you were here in town in DC 2-3 weeks ago for a hearing. Can you tell us about that? what the hearing was and?
Oh, yeah, guys, that was unrelated. So I was there for the Court of Appeals Federal Circuit for another, the last time I was in a hearing for your guys' case was May. And that was on the Jordan case. So there's two cases running in parallel.
That's what we're at.
Yeah, one is Lambro and one is Jordan. They're both, they're similar fact patterns. They're just the court sort of forced us constructively to do this based on its denial. But anyway, so when I was in DC the last time, and the reason I brought it up to you guys is that if I were to plan better, and I'd love it if I did, right? If I plan better next time I'm in, I have occasion to be in DC half a dozen times a year because I do a lot of business at the Court of Federal Claims there and at the Court of Appeals for the Federal Circuit. What I'd like to be able to do the next time I'm in town is have some kind of event. One of the guys on my staff that
Be happy to make it happen, man.
yeah, one of the guys on my staff that Jason knows lives there. His name is Ari Aramish. He lives there in the DC area. He lives right outside the Pentagon. Actually, you can see the Pentagon from his house, from his window in his apartment. And he's got a bunch of memberships at some bougie clubs in town, including the Army Navy Club, which I've got a membership there too, which would be fun. Maybe get some people together, and then have a Q&A. Use it as a mechanism for you guys to introduce other folks that might be standoffish about joining. There's still folks that are still scared. I mean, there's still folks that are worried that if they join this case, it's going to forever. I got an email like a week ago. They didn't really give a lot of reasons why. They just didn't want to join the case. And the reason that comes up most frequently is they're just afraid. They're afraid if they join the case, they're going to get, blacklisted in the government. They're not going to be able to get a job. And that's the difference between being able to feed their families and not. And I understand the fear, and I can't, almost any other point in history, I tell you that fear is not realistic. The government's not going to do that. They face too many legal problems if they do. But in this current day and age, I won't wax too political one way or the other, but I'll say that I'm not as confident that the administration won't color outside the lines and do things that they're not allowed to do. And then I'll have to go to the courts and get it fixed. Now, I have seen what I can say with some degree of confidence and what inspires some confidence is that the courts have been careful mostly to keep the administration honest with the enforcement of laws. So if we get too sideways on that front, then I've got, I'm very good. I recently submitted my admission to the U.S. Supreme Court because I see that's a place where, some issue, maybe not all the issues, not the big money issues, but some of the issues could end up there. So I'm being careful to make sure that I've got access to every court. I'm even doing a lot more work in California, which is where a good, decent crop of my folks live now. All right. Hopefully I answered everybody's question thus far. Let's see, it's 10:43. Who's got another question? Karen, based on what you said about the legality of more money than I claimed, I used the employer's equipment office space for the Yep, that's actually true, Karen. Karen's question is, based on what you said about the legality of 1099 versus W-2 employment, mean that I'm owed more money than I claimed? Sure, probably. The good news is I haven't locked in anybody's monetary amounts yet, right? So what an individual believes they're owed subjectively does not necessarily rule the day, right? That's why we have a forensic accountant who's going to crawl through everybody's stories, probably interview folks and put together an expert opinion on what's owed. Because again, a lot of folks don't know what they don't know. They don't know, for example, what is compensable and what is not. Many of you, for example, are paying for your own or have been paying for your own health insurance benefits. A lot of folks don't know that, in many states, that's illegal, or you weren't getting paid over, not paid overtime. That's important. We all know that. You weren't getting paid sick or
Time and a half.
sick leave or vacation pay. Most states, especially recently, and I say recently, and I'm not since at least like since the beginning, COVID put a big spotlight on this, right? A lot of folks who didn't have work related vacation or sick time, they became the state's problem because the employers weren't doing anything. And so the state said, yeah, that's not okay. And so a lot of laws, at least in the last 5 years, have changed so that folks have got to have, those benefits have got to be in place. Now, we'll have to go back and do an analysis of the state laws and when they were in effect and when they weren't and all that stuff. But that's our job. That's our problem. And I don't, what I've tried to caution people against in these types of meetings is don't make it your job to figure that stuff out. Right? Again, I keep driving this home. Your job is to tell your story, and my job and the people that I'm employing, including experts, their job is to figure out what you're owed. Now, if you don't agree with what you're owed, you're like, hey, Joe, you missed this, you missed something. We're obviously going to be all ears. The more money you make, the more money I make. So I'm going to be all ears to make sure that you get every nickel that you can get. I've got a baked in financial incentive to make sure that's true, which is also why I'm doing all of these creative legal arguments to reach back in time as far as we can possibly reach, because again, that your payday is my payday. So, I mean, I don't want to sound too overly mercenary on this front, but I want you guys to understand that our economic futures are connected.
Oh no, be a mercenary. I like that.
So, I mean, I want you guys, the reason I worry about sounding too mercenary is there is a school of thought. There are attorneys out there that we all know them. They all have very unflattering names like ambulance chaser and the rest. I'm not that guy. At least I believe that in my heart that I'm not that guy, but that person exists. And some of you have seen that person on TV and some of you have met him in real life. I don't want anyone to worry that I'm that person, that I'm going to make the first and easiest money grab. I've already been at this for 4 years, and I don't want it to go 4 more. But if it does, and it's enough, and it feathers the nest of the people on this call and the ones who will join this call in the future, then it is a fight I am happy to engage in.
Speaking of timelines, how do you see it sussing out? Just I know it's a guesstimate, it's a game. We don't have any crystal ball, but roughly, what are you thinking?
So I'm already like, kind of like the Yellowstone earthquake. We're already past due on when I would have expected Summers to issue an order on the May hearing. We argued that. I mean, and you were there. It was like 4 hours of oral argument, which is an extraordinarily long period of time. We argued a bunch of different issues, and he seemed to signal in that hearing that he was going to move on this quickly. I think he and I have very different definitions of what quickly looks like, and I neurotically checked to make sure that something didn't, slip by me in my email. And I'm not. There's not really a mechanism for me to miss anything because I'm submitting new forms pretty much weekly. When they're coming in, if they get threshold of 4 or 5 different forms a week, then I go in and put them in there. And so it would be impossible for something really to miss me, but I'm going to log on as we speak. Just to make sure, but yeah, the judge, in my estimation, is already past due. Now, depending on the way he falls, if he comes back and gives us most of what we're seeking in the first place, he's, the big, and you've heard me say this before, Jason, the big move right now is waiting for what would typically be called class certification. I filed the last filing was me filing in August, me filing a bunch of new folks that had joined the case.
Could he be stalling to affect the Court of Appeals, that he hasn't ruled on something, but then we go into Court of Appeals when he hasn't ruled on something, and then
we can't. What the mechanism would be called a writ of mandamus. So you can file a writ of mandamus with the Court of Appeals and say, hey, Summers won't rule. I will tell you that 999 times out of 1,000, the Court of Appeals will say yeah, we're not going to interfere on that front. There's probably a magic threshold out there somewhere that if the court went past it, I've got a case, for example, in the Eastern District in Virginia, EDBA, where the court said she was going to rule on a motion to dismiss in April of 2024 and hasn't. I'm about to set that case for hearing again because it's been 18 months almost, and set that case for hearing and say, hey, Judge, what gives? And if she doesn't do anything or tells me to pound sand, that would be an example for me to go up to the Court of Appeals. The Court of Appeals has been sympathetic to the trial courts lately because they've been a deluge of cases since COVID. I'm just hoping that excuse will run its course before too long. But right now, Jason, I would tell you that if Summers made a decision tomorrow, there is a universe in which, and it went let's say he's like, I'm going to certify the client. I'm going to, it's called an initial certification. I'm going to allow Whitcomb and the government to formulate a notice and send that out to the tens of thousands of potential litigants. In that scenario, there's a very good chance, based on what I've read in the dockets of other cases, that the government says, you know what, we're going to go ahead and try to move to settle this case, which would be its own process. That's not going to happen overnight. That probably would be another 3 to 6 month long process of negotiating the language and the terms and the amounts of the settlement. But until Summers moves, it's going to be a difficult thing. What I'm trying to say, it's going to be difficult to predict.
Doesn't he have a certain time limit, or can he just indefinitely not respond?
So the second one is true. He doesn't have a baked in time limit. Can he indefinitely not respond? There's the writ of mandamus. I could go up. I could do a motion for, I could motion the court for a status conference. There are mechanisms I could use to get the Judge Summers answers to essentially one person. That is the chief judge of the Court of Federal Claims, plus the Court of Appeals and the Supreme Court, of course. But the day-to-day operations, Judge Summers is going to answer to the chief judge in the court. That chief judge is going to have meetings, on a regular basis that says, okay, this is the average length of time a case has been on the docket. This is it's been 3 months, 4 months, 6 months, whatever it is. And oh, by the way, Summers, you're kind of dragging our averages down. Get busy. That's what that would look like internally.
I got it. So his boss kind of has to give him a little cattle prod to move him in the direction.
That's right.
Go around him to tell his boss that. So we have to kind of wait for his boss to see it.
You got to wait for the boss. You got to wait. I mean, yeah, there's some, what I know from 18 years of practice, right, is that there are baked in, ticklers and there's clerks and there's people in there whose job it is like, hey, let's keep this stuff moving. And you see it the other way too. You see judges doing really crappy things in the name of doing nothing else except getting people off their docket. No other reason.
Got it. Understood. I think Daryl had a good question there in the chats.
Oh, let me look here, Daryl. Yeah, many of us started at VOA as an LLC, POC, then PSC. How all these classes merge compensation? So, Daryl, the answer to that question is you'll have different. All that will affect is different damages models, right? Because as an LLC, you were clearly misclassified. POC, same thing, clearly misclassified. The difference between an LLC and a POC is, in my mind, is de minimis, because they were both, from everything I've learned so far, they were both 1099s. Then as a PSC, you moved over as a W-2, but you were still not treated like the regular GS employees of that organization. So in that instance, what I'll tell you is that the only way that it's going to affect you is the damages model. How much you were due how much you were shorted, I should say, during the different periods. Because I've talked to an overwhelming, because originally I thought, well, when these guys became PSCs, they made everything right. What I have learned did painstaking investigation, talking to a bunch of different folks that were always PSCs or were moved over to PSCs. Is the government just engaged in a different game, same game, different day? So they, in a different way. So they artificially suppressed overtime through different means when people became PSCs. So one lady told me this very interesting story where her first line, VOA W-2 supervisor told them all that I need volunteers for these days to be on call in case we have some breaking story, right? And people were like, yeah, if you pay me, I'm happy to do it. And she said, well, if you don't volunteer, you're going to get voluntold. Basically, you're going to be put on the schedule to do it, irrespective. And this was all without pay and without overtime. Like this was just because the idea, the incorrect idea that the supervisor had was if you're just on call, the government's not obligated to pay you. The case law says a very different thing. And I mean, the one thing that I regularly have to remind myself with regard to you VOA folks is that many of you, almost all of you, for at least a period of time, were under an amended or a modification of the contract that put you on call 24/7, which means you were due compensation for all of that time. Maybe not the full hourly rate, but you were due some level of compensation. Maybe it's minimum wage, but you had to be paid something while you were on call, and you weren't paid anything while you were on call, unless you actually showed up to work. Did that answer the question? No.
Yeah, kind of. Only thing I'm dealing with, if as an LLC, and even as a POV, they treated us like we were some type of vendor, stocking sodas.
Sure.
And that's basically how they treated us, and even as an LLC. So they were really wrong, and all of us wanted to work, but that was basically the situation. We kind of accepted that, but we knew it wasn't right. So that's kind of where I am.
And what I want to tell you, Daryl, is your instincts were spot on. It wasn't right, wasn't legal. They were paying you illegally. And I know that the POC model was a crappier model even than the 1099 model. Many of the folks that I've talked to that were in the POC model, they were paid on a per project basis, irrespective of how long it took. So it could be a boon because you did one project and it took you, 10 hours to do it and you got paid $400. And then other times it could take you 4 days to do it and you got paid $400. So the biggest problem, especially when the government is concerned with that particular model, is it had no authority anywhere to do it. There was no authority at all for them to do that. So it just, they're going to have some, as Ricky Ricardo would say, they're going to have some explaining to do as to how they got away with that. And the answer is there's nothing in the law that allows them to do it. The way it'll come down to compensation is, all of the time, the time that you spent doing that work, preparing for that work should all be compensable. And the fact that you had to pay for all your own benefits and you were misclassified in the first place. You should have been W-2 employees. You were doing the primary and essential role of the government mission. And you were treated.
I would like to share this. I've had confrontations, well, not confrontations, but actually worked with some of the high CEOs of VOA when we were doing our different programs. And one of them, I don't know if I want to quote the name right now, but I will send it to you, Joe. She says, well, when I say she, I think everybody knows, but she would always say, we have too many contractors here. She actually said that a lot of us should have been employees, but it never happened.
Not only did she say it, the State Department Office of Inspector General said it in 2013 in a 68-page report that I've included as an exhibit in this case. I mean, these folks were open and notorious about their violating of federal law. They also didn't have as many PSCs as they didn't have as many slots for PSCs as they were employing. They were breaking the law all over the place, though. I mean, all over the place. And you guys were victimized like 16 ways from Sunday. the difficulty I'm having in answering your question is, and I'm not trying to be evasive, it's really just, it's gonna take a lot of forensic accounting to ultimately come up with the amount that you are actually shorted. And I expect that number is going to be massive as it relates to the group. Because this was all just a money grab. This was all just a way for the government to basically extort and exploit their workers. And I say extort because many of the workers had a proverbial gun to their head because they were under threat of deportation if they didn't do what the government told them to do. The others were just exploited because you were brought into this job to do to do what the W-2s were theoretically supposed to be in charge of doing. And they found a way to do it for cheaper. And they acted like any other greedy corporation. And government employers are not supposed to act that way. And there are laws that prevent them from acting that way. So that's when we get into all of this, and this is why I keep emphasizing this many times, as you guys will bear hearing me say it, is go out there as many times as it takes to create this narrative and make sure I have all the facts. Because when the forensic accountants start figuring out what the government owes you when we get to that stage, I don't want them to be missing any information. And if they are, I'm going to charge them with reaching out to you guys and interviewing you guys and making sure that they've dotted every I and crossed every T.
All right, Joe, thank you very much.
Of course. All right, guys, we're at the top of the hour. I'm gonna close it off for now. Again, we're gonna keep doing these with a high degree of frequency, keep doing them every other week. The last time I slowed down, it was just because we were, in the middle of motions practice trying to get this stuff done. But now we have a little bit of a pause in the case. And when we do, I'm gonna make sure that we get Q&As done as quickly as possible. So I'll go back out, schedule another Q&A. It'll either be in 1 week or 3 weeks because I'm going to be gone on October 5th. So it'll either be the week before that on the 28th, or it'll be the week after on the 12th. All right.
Copy that. Thank you, Joe. Appreciate it.
And of course, guys, I'll send out an email to everybody in the group with this particular webinar on it, and then I'll keep adding it to the site so that people can keep getting access to it. Okay.
Sounds good. Thanks for all the hard work, man. Take it easy, everybody.
Talk
Yep.
soon. Bye-bye.
Thank you.